Hello friends, in the series on the discussion on various matters on income tax, today we have taken a very important issue on the limitation period where the tribunal remands back the matter to the assessing officer for de novo assessment order. Section 153 subsection 3 talks about the limitation period, which says that if the matter is remanded back and the financial year in which this remand back order is received by Principal Commissioner of Income Tax, then the de novo assessment order should be passed within a period of 9 months. Now it has been extended to 12 months should be passed. If the assessing officer do not pass the de novo assessment order means new assessment order within that limitation period of 9 months or 12 months, then he does not have the right to pass the assessment order, and if any interest or refund is due to the assessee, then it should be refunded to the assessee. This issue has been taken by Bombay High Court in the case of Lakhpatrai Agarwal versus Assistant Commissioner of Income Tax and others, and this case has been reported in 470 ITR at page number 123. The date of the judgment is 10th February 2023. Section 153 subsection 3 says that if the matter is remanded back to the assessing officer by tribunal, then the assessing officer has to pass the fresh assessment order within a period of 9 months or 12 months from the end of the financial year in which the order of tribunal is received by the Principal Commissioner of Income Tax. In the present case, the court said that the words used in section 153 subsection 3 is received and not till it is received, meaning thereby that it cannot extend the limitation period in perpetuity. This case can be understood with the facts of this case. In this case, the tribunal passed the order on 18th February 2010. So, the financial year ends on 31st March 2010. If we add 9 months, then the limitation period becomes 31st December 2010. But the assessing officer didn't issue any notice for completing the assessment, and near about 8 years the assessee waited, and when he came to know that some tax was paid by the assessee for the assessment of that year, then he claimed a refund of near about 7 lakh and interest on that near about 14 lakh, and write a letter dated 6th March 2018 to the assessing officer. But the assessing officer didn't take any heed to this letter, so the assessee wrote 2 further letters on 2nd May 2018 and 17th August 2018. Even after these 2 letters, the assessing officer didn't take any action up to 2022, and suddenly on 13th July 2022 he issued a notice under section 143 subsection 2 for completing the assessment. The assessee moved a writ petition to the Bombay High Court, and the Bombay High Court said that in the present case the assessing officer do not have any right to complete the assessment because the period for completing the assessment has elapsed a long period back. The court said that when the tribunal passed the order in 2010, then it was the duty of the assessing officer to ask a copy from the tribunal for the order passed by the tribunal, and even the assessing officer can take this copy from the assessee. The court further said that even when the assessee wrote a letter to the assessing officer in 2018, the assessing officer didn't bother to complete the assessment within 9 months from that date itself. So in the present case, the lex specialis approach of the revenue cannot be accepted, and the revenue is bound to refund the tax amount and the interest thereon to the assessee. Friends, this case is a classical example of the laziness of the department. There may be some cases where the matter has been remanded back, but the assessment orders have not been passed. So we can check our records, or the assessees can check their records, that if something has happened, then they can apply for the refund and interest on that. At the end of this video, once again I am repeating the name of the case. The name of the case is Lakhpatrai Agarwal versus Assistant Commissioner of Income Tax, and this case has been reported in 470 ITR at page number 123, and the date of the judgment is 10th February 2023.